03, Kendra Locklear versus Lumbee Trial Elections Board. Justices Mary Beth Locklear, Everett Moore, and Chief Justice Mark Brooks.
You may be seated. Good afternoon. I don't think they had me in mind when they built these glass screens. I hope everybody's having a good afternoon. We are here today for a Supreme Court of the Lumbee Tribe of North Carolina hearing involving Ms. Kendra Locklear versus the Elections Board. As is our custom, our intent to go through some preliminary matters, address some preliminary issues before we actually get to the substantive merits of this case and why we're here. As you know, the Supreme Court is a function of this tribe where we hear disputes between tribal members of issues that arise out of the Lumbee Constitution and out of tribal ordinances. And I thank everybody for being here today. I'm thankful for those who will watch this hearing on live stream. I believe that it is extremely important, and it's a beautiful thing when people are involved in the tribal government. People are attentive to what's going on in our tribe, and people actually care what's going on in our tribe. So I do thank everyone that's here today. As a custom, one of the things that the court often does is we take a inventory from all the parties and from the judges of any potential conflicts or any potential concerns that any of the parties have with any of the persons on this court. As you probably recognize, there's only 3 of us up here, and that's not by design, that is by circumstance. It is the will of the Lumbee people, according to the Constitution, that the Supreme Court consists of 5 members, 3 lay persons and 2 persons who are graduates of accredited law school. It is very important to those of us that are sitting on this court, and I would hope that it is very important to every member of the Lumbee tribe that they would want the Supreme Court to have a full complement of 5 justices. And although we're not quite there yet, we're hopeful that in time and in due process that this court will have a full complement of justices. But this court is here today, and this case will be heard today by this court. I will begin with the petitioner and ask if the petitioner has any concerns with the panel of the court that they would like to be made known at this time. And I would just say, just for clarification's sake, if when the parties gets their turn, if the party has something substantive to direct to the court, if they would come to the podium and speak into the microphone. And I know we all have our masks on, but of course you can remove your mask when you get to the podium. Feel free. One other thing that I will say, as far as just the procedure of the day, there will be times where the court will likely, at its own discretion, pause, take a recess, deliberate on certain matters, certain rulings. That will probably give parties an opportunity to take a break, use the restroom, and other matters and so on. Petitioner, do you have any concerns with the court?
No.
Mr. Bullard? And Mr. Bullard, while you're here, I will comment that you were not a named party in this action. This was an action where Ms. Locklear filed the action against the Elections Board. You being the other candidate in that District 4 tribal race, the court felt that it necessary to treat you as a named party. So that's why you were given notice and invited. So you today are to consider yourself as a respondent in this matter. Elections Board?
Your Honor, the election board has no concern, just have some house cleaning questions.
Okay, all right. Justice Locklear, do you have any concerns? Anything you'd like to disclose to the court?
No concerns.
I don't have any concerns, Justice Brooks. I just have one statement to kind of reiterate that you kind of mentioned briefly. There's only 3 of us up here, and there should be 5. It won't be but a few months, and my term will come to an end. So that only leaves 2, and I think it's an important step that we encourage our council members, our Lumbee tribe, or our chairman, current chairman, and chairman-elect to make an effort to fill all positions to be fair as an entire court. That's the only way you can do it. Is you need 5 to be completely fair, and I just hope that the correct steps will be taken here in the near future, so we can be a very fair court. Thank you.
Thank you, Justice Moore, for those remarks. It's a difficult, but it's a rewarding task to sit on this court, because you don't really get to anticipate the questions and the controversies that you're going to be presented with. And a lot of times you sort of take for granted that persons will be able to hear a case and be free of any conflict. And in this particular case, through no fault of any person that's in this room, I think it really highlights the importance of what Justice Moore has just stated. I perceive that I individually have a conflict in this matter, and it's not one that is of sinister concern, but it is one, given the delicate nature of this court, and given the scrutiny that's been placed on this court most recently, that it's probably best that I, as Chief Justice of the court, would recuse myself in this matter. One of the things is, when you practice law, is you become a servant to a number of people, and you become a servant to a number of people that become close to you and become family. And as it's been stated a number of times in this court on the record, is that a justice, in order to hear a case, has to believe and be persuaded that a reasonable person, if they were in their shoes, they could rule on a matter objectively and impartially. Without going into detail, there is a family member that I am personal representative of, legal representative of, that is close to these proceedings, and given that and the consequences of that and the implications of that, I think it would be best if I would recuse myself from hearing in this matter. I could probably say to the parties that I could give a impartial ruling in this matter, and I really believe that I could be impartial. But given the current state of our tribe, and given the current state of our tribal government, and given what other persons might perceive a reasonable person could or could not do, that's my ruling on that particular matter. And I will comment one last time on Justice Moore's remarks. It's not fair to Justice Moore and Justice Locklear to have to hear a case of such importance as yours, Miss Locklear, and certainly that affects you too, Mr. Bullard, and you as well, Elections Board. We have experienced some turbulent times over the past 2 months, and the Elections Board has been busy, to say the least, over the last few months. They are an indispensable part of this government. And so when there is a tribal petition that is filed that involves anyone, and it involves questions arising from the tribal constitution, I consider them sacred, because they're the rights of the Lumbee people to come to this court and be heard, and to have a court that they can rely on and place their trust in to make a good faith decision that this government and the people in this nation may not all agree with, but can have confidence in, that they made a decision that they felt was the right decision, was the fair decision, and was the decision that was based on the evidence that was presented. It's not that it's impossible to do with justices that are less than 5, but it makes it much more difficult to get the thoroughest of hearings. And so it will be a very valuable thing and a wonderful thing for this court and for the Lumbee people, if this court can get additional justices that can help. We're going to take a brief recess so that the court can kind of make arrangements going forward, a very brief recess. But before we do, are there any comments or any inquiry by the parties?
Your Honor, I have just 2 minor inquiries that may get able to ask by Mr. Rowland. I wanted to make sure that the respondent had not filed a response, because we did not get a copy. I didn't know if there were any additional affidavit. And assuming that we didn't get a response, I just sent
You asked who provided a response, Mr. Bullard?
yes.
Mr. Bullard did provide a brief response. Can we get the Elections Board a copy of that, Mr. Roller?
Yes, sir.
I would like a copy as well.
And as well as just a house cleaning, Your Honor, I wanted to make sure we didn't need to push nothing or do anything, not to talk as far as the microphone. I want to make sure if they're being recorded or not being recorded, to speak.
Mr. Roller, can you comment?
Yeah, if the blue light's on, it's on, so you don't need to push the buttons or anything.
That would be our housekeeping.
Ms. Locklear, did you get a copy of
I did not. I
Mr.
would like
Bullard's
a copy.
response? Well, she probably needs one as well,
Yes,
Mr.
sir.
Roller. Can we get them a copy of that before they go on the recess so they can have an opportunity to review that?
Yes, sir.
Any other concerns before we break?
No, Your Honor, that was only a housekeeping matter.
Court will stand at ease.
We wanted to take a moment to introduce ourselves. My name is Mary Beth Locklear. I'm from Laurinburg.
I'm Justice Everett Moore. I'm from the Prospect community, and I've been a justice. I came on in July of 2017. And at this time, we're going to let each party briefly, we need just an introduction and a very, very brief summary of number one, why you're here, and number two, if it applies to you, what you're asking as far as relief. Very brief. This is not sworn testimony or anything yet, but just a brief summary introduction.
Your Honor, may we have a housekeeping moment, and we would also object at this point to moving forward until we can be heard just briefly.
I'm sorry, say that again.
In regards to the Judge Brooks recusing himself, we are now set with a new precedence that may be set in which there will never, for the first time, be a case heard without an attorney represented by this court. As such, we would object to moving forward and request to at least be heard briefly in the matter, because we would be setting precedents by moving forward without an attorney on the court. I would just like to be heard and the court can rule.
We don't have a problem with it. If you take just a few moments, we don't have an issue with that at all.
And would the court wish for me to appear at the podium?
Yes, please. Yeah, and that's a good point. Anyone that wishes to speak, even though we do have microphones at your seats, we'll ask that you please step to the podium. Thank you.
Good afternoon, Your Honors. My name is Crystal Graham. I'm appearing on behalf of the Board of Elections. When we arrived here today, we did not anticipate the recusal of Justice Mark Brooks. As such, we entertained the idea of moving forward with 3 justices, but at least 1 having a law degree and 2 laypersons. We did not have concerns with that because there is precedence for it, there is case law for it, it is of record. But at no time since that case law, with the time of Mr. Henry Ward, has there ever been a case that's not been heard with at least 1 attorney sitting on the courts. Now, that's no disrespect to the courts here, because certainly you have experience and you have knowledge. We would like to take the opportunity for the courts to understand that you would be setting precedents moving forward. That, again, not only can it be heard with a limited number of judges, but that it could be heard with no attorney on the court. And that's moving forward forever. So our concern is not for this case. There is no reason for us as the Board of Elections to believe that these 2 justices couldn't be fair, reasonable, and unbiased. That's not what we're saying. Or that you may not be knowledgeable. But because it is a new issue that will carry weight forward, it should be considered. And we don't want to be that party who simply acquiesced to it or to say we consented to it, and therefore, from here on out, any case moving forward is precedence. It is now law. Now, I'll make the same arguments that were made before Henry Ward a long time ago, and he decided, and that case is still case law, has not been set aside, that even though it says at all times 2 sitting judges shall be graduates of accredited law school, 3 shall be laypersons. At no time has a case ever been heard without the accredited attorney. And that may put us at a disjustice. It may, in fact, help our case, one way or the other. But it is something to be considered today because it is monumental. This is not a case where we had 1 judge who's an attorney and 2 laypersons, which we thought we were moving forward with today. And we need you to rule on that motion because it will carry weight in the future. And we're not here to make an argument for or against it. As an attorney, doesn't have anything to do with this case, Doesn't have anything to do with you two individuals or petitioner or respondent. It would give me great concern to come before court without an attorney on this court, any matter. And again, we may be at an advantage today, but we also could be at a disadvantage. It just gives us great concern on any matter. And you're setting the rule of law to move forward. And I realize that may do a great injustice to Mr. Bullard as well as a great injustice to the petitioner. But I don't know that in any matter ever heard in this court, it would ever be anticipated that no attorney would be sitting on a court rendering decision. Any questions?
Thank you. I don't have questions.
I don't have any questions.
Okay.
Just a brief comment to that. It's completely understandable, and that helps clear. That'll help clear up my next comments. Is that we did take to oath to abide by the Constitution and the ordinance, of course. Yeah, we're true. We're lay people, and so any testimony, any arguments that you made today, it needs to be very, very detailed, and it needs to be very, very clear. I understand, Ms. Graham, your concerns. I really do, and you can track that back all the way to our opening comments to where, you know, we need people, law people, you know, as graduates with law degrees that are willing to, you know, volunteer for this position. It's not a paid position; it's a volunteer position. And the tribe, we need to feel everyone. So, thank you for your concerns. And at this time, I think we'll move forward.
And you know, just again for housekeeping, that would be the court denying our motion. Correct?
Yes.
Okay, thank you. Now Ms. Kendra, if you would step forward, please. We're going to give you the opportunity to briefly introduce yourself and very brief summary of why you're here and what you look as far as relief. Thank you.
My name is Kendra Locklear. I was a candidate for District 4. Today, I stand before you to contest the election for District 4.
Ms. Kendra, you can remove it while you're speaking, so we'll make sure we get it clear. Thank you.
Today, I stand before you to, as I had filed a petition to contest District 4's tribal council election. The reason being is the election was flawed, in my opinion. The elections board failed to maintain accurate district maps, and they also distributed those inaccurate maps. They failed to maintain accurate election records, including the poll book, as when I went into vote, my name as a candidate was not in the elections poll book. They also failed to allow eligible voters who properly appeared at their polling site an opportunity to vote, including they denied them the option of to vote with a provisional ballot. I feel that this election, in my opinion, and the issues that I've addressed thus far proves it's impossible to determine that the elections of this outcome of this election. Thank you.
Your Honor, we have comments, but by way of introduction, I didn't know if you simply wanted a brief statement of the facts or if you wanted an actual introduction to the party, because I am not the party, but I am the party. Okay. And again, we'll keep it brief. For the Board of Elections, Ms. Locklear did challenge, and she filed her unofficial challenge, or excuse me, her challenge of the unofficial results. As a result of her first challenge, we asked her to supply facts. We asked her to supply witness statements, witness names, witness addresses, so that we could in fact investigate her claims and we could substantiate her claims if there were material facts to it. Ms. Locklear did respond. A copy of her response was included in our exhibits. We did not have witness addresses, witness phone numbers. We were given 2 names, which we could not locate in District 4. The other third name we were able to locate in District 4. We were able to validate that he was not an eligible voter, but he was still given an opportunity to vote provisionally. Of the allegations, we simply could not substantiate her claims because we couldn't find facts. We couldn't find affidavits. We couldn't find witnesses. All we had was allegations. As a result, we dismissed her challenge, and then she appealed it here.
Right there's Sam.
Louise. That's things. Oh.
Hello, I'm Linda Maynard Oxendine. I'm the treasurer for the election board, and I will support what Ms. Mitchell has stated. We did do due diligence to substantiate if there were error on the election board, and if so, to be totally responsible for any error that had occurred, and we could not find any error on the election boards.
I'm Rubelina Hunt Locklear. I serve as the secretary for the Lumbee Tribe Election Board and do stand by the decision that we made with the facts.
I'm Lakeisha Hammonds, and I am the clerk for the election board, and I sent out a request to see.
Thank you. At this time, I'm going to ask Mr. Matt Roller, and we're going to do this as a group. If you have intent of testifying for any purpose, we're going to ask that he affirm all persons that will be doing that as a group. And I ask that you do that at this time.
Could you please stand and raise your right hand if you plan on testifying? Do you solemnly swear that the testimony you're about to give before the court today is the truth to the best of your knowledge?
I do.
Thank you.
Thank you, Mr. Roller. At this time, Ms. Kendra, Locklear, please. The burden is on you. You are the petitioner. And at this time, you can proceed to the podium, and at the best of your ability and as clear as you can, please cite any argument that you have or any allegations that you have in your petition. You had quite a few. If you would please, to help us out, if you could start in your petition, you think, is it true that you numbered them 1 through 8?
That's correct.
If you could start with number 1 and continue through number 8, and please provide all information that you have to support number 1 through 8.
Yes, sir. So regarding election ordinance violation, section 3.5, distributing to candidates a copy of the Lumbee Constitution, ordinance on the election regulations, and any other election materials. Regarding the district maps, on the day of the meet and greet, we were provided a copy of our District 4 map. Normally in a past election I have ran, there was a large map displayed in the office. Elections board moved to a new location. They did not have a District 4 large map in place the night of the meet and greet. Or let me restate that, when I went in to file for an election, they did not have a large map. The map that was provided to us, I seen as the map that we would use to go out and solicit and talk with tribal members within my district. Can I get my notebook? On October 15th, I received a notification that the maps were inaccurate by Ms. Louise Mitchell via phone. On October 20th, I went into the office and picked up a new map. The map that I received, it increased the size of our district. By the time I received this new map, it was on October 20th. I think it was like 20 days prior to the election. And at that time, I had already talked with several members in our district that were on Mount Tabor Road and within the vicinity of the new locations or the new roads that were added, and I told them they were ineligible to vote in our district. After receiving this new map, I learned that these individuals were in fact in our district. Therefore, the map that was provided was just inaccurate. Regarding election board ordinance violation, section 3.5, distributing a list of voters' addresses in a format determined by the board, that also goes back to the maps and how they were distributed. Again, I went out and talked to several members prior to receiving the updated maps and told them they were ineligible to vote in District 4. That again goes back to my second point of argument. It forced these maps, in fact, there was also a third map. This is the map that's actually on the tribe's website, the Lumbee Tribal Council District Maps. This map also is not a representation of either of the maps that were provided to me.
Ms. Kendra, are those maps that were provided in your petition? Do they have a number on them or exhibit number or anything?
I did not provide an exhibit number on these. I did in my email that I provided. I don't recall if it was like 1 and 2, exhibit 1 and 2, but I have a copy if you would like these maps.
Mr. Roller, do you know if we have a copy of?
Yes, sir. Anything Ms. Kendra sent in is in a copy of your folder.
Okay. All right. You can continue, Ms. Kendra.
This map, in my opinion, the one that's on the website that has Mr. Ted Woodell's photo on it, exhibit 3, this map is public. Any tribal member that goes to our website, no matter what district they're in, they can actually see their district and they can see where the polling site should be and what district they're in. This was approved in 2016, according to the map, the Lumbee Tribe's website. This map is not a representation of either of the two maps that were provided to me. So therefore, where does a member go to verify what district they're in by looking at a map? Which map is an accurate map? These maps cause, not only the map on the website causes confusion with members in our districts, because they're looking to a tool to be able to determine what district they're in, which in my opinion could have potentially caused issues for several people in our community that came to vote and were not allowed to vote. And we wonder why we have bad numbers when elections roll around. My third point regarding the maintaining accurate election records, including the poll book. I went in, my son turned 18. This was his first election ever participating as a voter. My family and I went in together. When we went in to vote together, he was on he was in the poll book, the member book. When I went up to vote, my name was not in the poll book. It was not there. I thought it was kind of crazy that as a candidate for an election that I'm not in a book where I know for a fact that I am an enrolled member. My card was accurate. I done everything that I was supposed to do to maintain my membership. When I got up to vote, my name was not in the book. The lady told me that immediately I know she's in that book or should be in that book because she's on the ballot. So they allowed me to vote. I can't say the same for several people that I seen come out of the polls that were not allowed to vote. I had the flu at the time. I notified the elections board when they called me to respond with facts. I had the flu at the time. Because of COVID, there's no way that I was able to go out and solicit information from people who were not able to vote. I'm not going to put my membership in that situation. Number two, there were people that walked out of that polling site that was not able to vote, that was highly upset. I know for a fact were elders in my community, and one come out and went straight to his vehicle. The other came out. He basically said, I have always voted in this district. This is my district, and I went in to vote, and I was not allowed to vote. I will never vote in an election again. Is this what we do now to our people? Is this what we do now? Because at the meet and greet that night, one of the questions was, do you guys let anybody vote? Yes, anybody can vote. If they show up to vote, they're going to vote. We're going to give them a provisional ballot. That was not what the elections board allowed to happen at our district. There were people that went in to vote that were not given a provisional ballot. We were sending our membership all over the county to try to determine what districts they're eligible to be able to vote in. And we wonder why we have an issue with elections.
Ms. Kendra, are any of those persons or people here today to testify that they weren't allowed to vote?
Mr. Moore, I'm going to be honest with you. When you go to vote, there are people coming in and out of that polling site. Do you know every single person that lives in your district? Absolutely not. I don't either. I know people, elders in my community. I can probably tell you some of their names, but majority of them I can't. It's not my job as an investigator to try to determine who walked out of that polling site that weren't able to vote. I do know that the judge that was in there that day, she was texting back and forth. I don't know if she was texting the elections board or an enrollment office or who she was texting to verify people in our district if they were eligible to vote. I do know that if she still has those texts available, that is a record. That's not something that I can get. But I do know that visually, I've seen several people come out of that our district that were not allowed to vote. One person I know for a fact is Ronette Gerber. I provided that information. Ronette is an attorney. Ronette stays across the street. She stays across the street from the Philadelphia's polling site. When she originally went in, they told Ronette she couldn't.
District 4's voting.
Yes. Her house, you can see it across the street. She's an attorney. She walked in, they told her she couldn't vote. How is that acceptable? That's where her and her family has always voted. Ronette being educated, and Ronette knowing what she could and what her rights was as a Lumbee member. She knew. She was educated enough to know it. But what about the people in our districts that did not know what to do? What were they left to do? I know that two elders walked out of that building upset that they were tribal members and they were not allowed to vote. Is that what we do to our elders now? Because if I recall correctly, at a meet and greet, I was told everybody will be allowed to vote because have you ever been in front of a person at a polling site and told them they couldn't vote? What happens to our people? They want to fight you. That's what I was told.
Ms. Locklear, you've mentioned the meet and greet a couple times, and I'm gonna
Yes,
be
sir.
honest, I've never attended one, so I don't know who all at the meet and greet. I know it's candidates, right?
Yes, sir.
Who else is involved in this meet and greet?
At the meet and greet, it's all of the candidates that's included on the ballot. Also at the meet and greet is our elections board. It's everyone from the elections board and everyone that works in that office as part of the elections board is in attendance. That meet and greet event is normally that was my second one. It was the most professional of the two that I've ever attended. I was very excited about that meet and greet when I left from there. I told almost everyone there that night how wonderful it was. And they provide us with what I see as our tools as a candidate. They provide us with the tools that we need to be successful in an election as a candidate. That's what they do. They provide us with these various documents, including the map that I've seen as this is my tool that I'm going to use to go out into my district and talk with my membership.
Now, in that meet and greet, do they make it, I guess it's the election board, do they make it clear if there's any changes, how you will be notified?
No.
When they give you the maps of your district, do they say these are?
Yes.
They don't make a statement that these are the official maps And if anything changes, you will be notified.
This is a copy of your map. That's what they tell us. This is a copy of your map.
And do they make it very clear that if you have questions, you know who the point of contact
Yes,
is?
they made it clear that if we have questions, we can contact. They made it very clear that if we have issues or questions the day of the polling site, they gave us contact information. Yes.
Ms. Locklear, going back to the witness that you had mentioned, or another person, Ms. Garber, I see the evidence she provided with the text message, so she eventually had a chance to vote?
Yes, she was able to vote.
And how did that transpire?
I do not know.
Okay.
I don't know. All I asked was I wanted to just make sure she was able to vote, and she was able to vote. But it goes back to my point. Ronnie is a unique situation. Not everyone was in the same boat as Ronette. If you're on social media, you've seen the upset membership in our communities. It's not a secret that people are upset because of poll. And I know that the elections board has nothing to do with how our enrollment is structured. I know that. I also know that they can't help who's in the book and who's not in the book. But I was told that regardless of who walked in that door, they were going to be able to vote, whether it was regardless, they would be given a provisional ballot. That was not the case. That did not happen. That's what was told on the meet and greet night. But it was not the case. And that made me upset because of the fact of the matter is there were people that showed up that I know for a fact that was in my district that were not allowed to vote. Do I know their names? No. Did I have the flu and go out and ask them and contaminate their homes and say, can you give me your statement? I did not.
Okay, Ms. Locklear, what number are we on?
We are on number 4.
Okay, continue, please.
Lumbee Tribal Constitution, Article 2, Section 4. The voting general membership shall consist of members of the tribe who are 18 and older and who are registered voters in accordance with dual adopted tribal ordinances. I think I've already spoke to that issue already. The next is Elections Board Ordinance, Section 4.2.a. Any eligible voter may vote by appearing at their voters' prescribed polling site, announcing the election precinct committee his or her name, address, and signing the ballot sign-out sheet. This goes back to the maps issue. It's been years and years ago since I had to go into the office and update my tribal card from moving from Prospect, which is where my husband and I lived prior to moving over to the Philadelphia community. But when I did go in and update my tribal card, I knew what district I was moving into because my grandfather was a tribal council member at the time. So I knew I was moving into the Philadelphia district and I didn't have an issue. But I do recall that when I went in and updated my tribal card, I was not told what district I was moving to. That was not part of the procedure, our normal tribal procedure in the enrollment office. So if I would have been any other member who moved from a district or moved within another district, how would I have been told what district I was in? How would I know what district I would be in? My first instinct is to go to the Lumbee Tribe of North Carolina's website. The Lumbee Tribe of North Carolina's website presents maps. If I look at my District 4 Lumbee Tribal website and look at my map on District 4, I'm in District 4 on this map. But guess what? This map looks nothing like neither of these maps. Neither of them. I don't recall correctly right now where this map extends to or where it does not extend to, but I do not think it covers the full precinct or the area in the Red Springs area. All of that area, but I do know it looks nothing like either of the maps that was provided to me by the elections board. So we're not doing our due diligence to ensure that our membership knows what district they're in to be able to vote. It's not on our tribal card, and it's not accurate on the website.
Ms. Locklear, do you think, or is it are you under the impression that the maps on the Lumbee Tribe website are official maps?
Based on looking at the website, you will see on the Lumbee Tribe of North Carolina's website, at the corner, left corner of this map, you will see the Lumbee Tribal Council districts. District 4 was approved on 8/22/2016. So yes, I see that as an approved map.
Okay, continue on, please.
Number 6, the Elections Board Ordinance. 5(1)E. I feel that I've already explained that in great detail as well. Section 6(5)A, the outcome of the election would have been contrary to reported results. I think I may have skipped one, so give me a second I apologize.
Can you elaborate any at all on number 7, please?
Give me 1 second, sir. I'm sorry.
Okay. Take your time.
I've got my papers mixed up. I'm going to go back to 5(1)E. I don't recall which number that is. I'm going to go back to Elections Board Ordinance 5(1)E. I think that may be 6.
Yes, ma'am.
Okay. So as part of this process as well, there are absentee votes. And the Elections Board provided, it is my understanding that Elections Board provided our membership that was out of district, out of territory, or was unable to make it to the polls to be able to cast their ballot. They were provided with return, well, first of all, their ballot. They had to verify that they were a member, had to verify, they had to meet certain criteria and verify that they were eligible to be able to receive an absentee ballot. But once they were verified by the Elections Board, they were provided a return envelope. That return envelope was sent to them by the Elections Board. A member outside of my district reached out to me and informed me that she received a return envelope. The return envelope had postage that was placed in the wrong location. When she went in to send back her absentee ballot to the Elections Board, she was notified by the Postal Service that this envelope would more than likely get kicked back by the system.
Affidavits too, or the is
Can you repeat that, Ms. Graham?
we would object to any evidence out of the district. Number one, the only that's of 15 days. Number two, we'd object to statements from witnesses who have, one, not made a sworn statement or been, or two, who are not here to testify across.
That's fine. I have a copy of the envelope that was presented to me, and this envelope, you can clearly see the postage was put in the wrong location. My argument is about, we received, that I'm aware of, 2.
Again, I would ask the court to move on my.
Okay, just a point of clarification. The envelope, what district is this? Is this not district
I don't know
4?
what district she's in.
Um.
I don't know how, with the absentee ballot process, if a person, it's been told to me if they have a home district that they lived in. I know the lady used to live across the street from me. I don't know if she received a ballot from my district. I don't know. I didn't ask that question. I know she used to live across the street from my parents. But I don't know how she voted. I don't know what her ballot looked like. I don't know anything related to that.
Okay.
All I know is she stays in a different area outside of our tribal territory. So I don't know how that process works, if they receive a ballot for their home territory or not.
Okay, if we can just pause a second and let's Justice Moore and I talk about the objection, please, just a second. We're going to sustain the objection, please. I mean, I don't think we can really accept the envelope if
That's
that's
fine.
out of district. So,
That's fine. And then the last item, I think, well, we're at number 7. I have to keep this page out, so I don't have to keep it back. Sorry. And then the last item, I think it was item number 7. No, the last item was 8. So with 7 regarding the mathematical numbers. Oh, how much sheet? Regarding section 658, outcome of the election would have been contrary to the reported results. I feel that if the maps would have been accurately represented, membership would have knew exactly what district they would have been in. I also feel that membership, when they would have showed up, they would have been able to vote in their prescribed districts. I feel that membership, when they would have been, if they were not been in the enrollment book, regardless if the enrollment office provided the wrong information or not had the correct enrollment information in there, they would have been provided a provisional ballot. I feel that this election would have been different, and we would have allowed members to be able to vote. So therefore, I feel that the election would have been contrary to the reported results. And then number 8, section 6.5b, it proves it is impossible to determine with mathematically certainty with which candidate is entitled to be certified as elected. I think that falls back on that as well. As the on November 24th, the Lumbee Tribe election certified election race pursuant to the Lumbee Elections Board Ordinance Section 7, and declared Jody as the winner, Jody Bullitt as the winner, vote of 106 in comparison to 102 by myself, which is a margin of only 4 voters less than the number.
Ms. Kendra,
Yes.
what is the margin of votes that requires a, I don't know what the correct term is, a runoff for the election?
I think it's 1% or less. Is that right?
Well, I should have said on your, based on your understanding, 1% or less.
Yes, sir.
Okay, any more comments on number 8?
No.
Ms. Locklear, are you aware of any other prior cases that required to have a new election? That either, it can be either the Supreme Court heard or the Elections Board. Are you
I do recall at least one case that had a new election, but I don't recall which one.
They had a brand new election.
Yeah, but I don't recall which one.
Ms. Locklear, do you understand that everything that you're looking for relief here, numbers 1 through 8, it needs to be proved with substantial and material evidence. Do you understand that?
I do.
Okay. There we go.
Do you have any other evidence that you would like to present?
Do you have the colored maps?
We do.
Do you have the text messages from Miss Andrea Branch?
Yes, but give us a moment to pull it in front of us.
Yeah, we got limited workspace up here.
I'm sorry. What did you say?
Give us one moment to
Just a
get it in
second.
front
We
of
got
us.
very limited space.
Yeah,
up
that's
here.
the issue that I'm having as well. So I apologize for my rambling earlier.
You say from Miss Branch?
Andrea Branch, yes.
Is it just one page? One text?
It's screenshots. It's 2. Attachment 2 and 3.
Okay, yes, we have it in front of us.
I wanted to make sure you had those.
Would you like to
Elaborate?
elaborate on that?
Yes. So as stated, Andrea, I don't.
Second, Miss Locklear. Does everybody have a copy of this?
We would say, as long as it's the same one that was submitted in her petition, they'd have a copy.
Yes.
Okay, continue, Miss Locklear.
So, Miss Andrea Branch, I don't recall if she was a chief judge. I just know that she was. I think she was, but I'm not 100% sure what her official title was that day. But she was working as a judge at a polling site, and as noted, when I walked in, I did notice that I told her, I gave them my name. They told me I weren't in the book, and I looked so shocked. I guess she said. She said she's literally on the ballot. My aunt says, how can this be acceptable? And she held up her cell phone and she scrolled through all of these names and different text messages that she was sending. She said, I've been at this all day trying to verify people who are eligible to vote. So when it came to a point where I was trying to determine whether I was even going to file this petition, that came back to my mind, and I thought about all the elders that come out of there, or the elders that came out and that were not allowed to vote, and I thought it would be injustice if I did not stand up and speak for my people, noting that that was the reason I was running in the beginning. But I did reach out to Andrea Branch, and I asked her if she was aware that anyone was able and eligible to vote as a provisional. And you can see her response here. She did say that she was sending those text messages to verify the location for folks that were not listed in the polling site book, so they could go to their correct polling sites to vote or verify voting eligibility. She said that based on those calls and texts, we were able to direct all those folks to the correct sites. So they did send people away without provisional ballots. Those were people not in our district, so a provisional vote in District 4 would negate their vote. That would count in a correct district. We only had at least one person that asked to vote provisionally, but then they changed their mind and didn't want to go through with it, the process, when they realized their card had expired, and no matter how they voted, it wouldn't count. I asked her if she knew how many were directed to other sites. She said, no, not right off.
What was Miss Jacobs' position again?
I think she was, I don't know if she's a chief judge.
And this correspondence was sent when?
I don't recall the date, but I can go
It was
back.
on election day?
It was what?
Election day, or?
This correspondence was after, when I decided that I was going to file a contested election.
Anything else, Miss Kendra? You told us to pull these maps out.
These maps, this is the maps that I was referencing in my email that I originally sent to contest the election. I think I just took snapshots from my cell phone and provided those because I wasn't able to print those off. And basically on the original map that was provided to me, I don't recall if it was Exhibit 3 or 4, what it was, but Exhibit 3 was the one from Lumbee Tribal Council on the website, the district map. If you look at the 3 maps together, that the one's on the website with Mr. Ted Woodill's photo, the second is the one that was provided at the meet and greet, and the third is the one that was the updated map. If you look at these maps, they're all 3 different. The only map that I see approved on is the map that's on the tribal website, and it looks nothing like the ones that were provided to us.
And when was it approved according to the website?
According to the website, it was approved 8/22/16.
And you were given these other maps, one at the meet and greet, correct?
Correct.
And then you were given the so-called updated map on 15th?
October 20th.
20th?
I was notified on the 15th that the maps were inaccurate.
Okay. I don't think I have any further questions for Ms. Locklear.
No, not at this time.
Any other comments, Ms. Locklear?
No.
Thank you, ma'am.
Thank you.
At this time, the court is going to ask Mr. Jody Bullard if you have any comments or any testimony. If you do, would ask that you step to the podium. Mr. Bullard, all we received from you was a brief comment, correct?
Yes, sir.
Hold on just a second, let me find that. All right, Mr. Bullard, you can go ahead with any comments.
There's a
Any
couple of
testimony?
comments that, even with the correction of the maps, I think we had adequate time. I think I recognized some of the locations, being a previous candidate in the past, some of the past races, that I kind of knew that some of those candidates that were in that district. Immediately, once I recognized it, I contacted the appropriate parties that need to be contacted, referenced incorrect maps, and I think again it was 20 days before election time. I got out, went to other folks' house and notified them in an appropriate time manner that you still had time to vote or where you could vote at. And again, some folks coming to the election site that day, they immediately knew, well, hey, this is where I come to vote. I asked them, where do you live at? And some folks said, I live across the district line, gave them the right direction of where they needed to be voting at instead of coming inside trying to see if they vote there. Again, knowing your district is very important. And again, to some folks coming back to vote, they said, well, this is where I vote for all elections. And I think that's one confusion that we have with some of our folks in the community, is that they come to vote at certain locations is where they vote at for all elections, whether it be tribal elections, Senate, president elections. That's where they come to vote. And then they assume that's where they vote for everything.
Mr. Jody, did you attend the meet and greet
I did.
where you issued maps at that meet and greet? Your District 4 maps? At the
I
meet and
was.
greet? Did they offer clarity to you that if you had any questions, who your point of contact was?
Yes, sir. Even at the day of elections, if we had any more, if we had any complications or any problems, we were told to contact the appropriate parties, whether it be the judge on the inside or either Board of Elections.
So, so how were you? Did you receive a different map after the meet and greet,
I did.
or were you made aware that the district had changed a little bit?
I was.
What date were you made notified?
I honestly can't remember. Again, it was by phone call. Again, after I contacted appropriate parties, also
A phone call from
the Board of
somebody
Elections.
with the board.
Mhm.
Did you receive a new map?
I did, sir.
Do you know what date you received the new map on?
I don't. I can probably clarify it as far as by email.
How did you get your hands on a new map?
I went out to the Board of Elections.
You remember what date that was on?
I do not, sir.
Any questions, Ms. Mary Beth?
No.
Any other comments, Mr. Jody?
No, sir.
Thank you for your time. At this moment, the court's going to go into a brief recess, probably 20 minutes or so. Thank you.
All right. Excuse me. All rise.
And just to be clear, for your response, Miss Kendra, you can stay seated, okay? And that's true for you, Jody, and true for the entire election board, because it'll be a little bit of cumbersome to try to get, if y'all have multiple speakers, it's going to be aggravating trying to get everybody to the podium. So if it's okay with everyone, you can just speak. If you have a comment, you can just speak from where you're at.
So we'll have the opportunity, if Mr. Bullard, if you have questions for Ms. Locklear, and then Board of Elections, if you have questions based on her testimony, and then we'll afford the same opportunity for you, Mr. Bullard, since you've had a chance to stand and speak, and then we'll have the full response from the Board of Elections after that. Sure.
We could just have one.
Sure.
We do have just questions.
Okay.
Ms. Locklear, what day did you come to the Board of Elections? The ready to have?
October 20th.
Are you aware that the maps would not have been corrected by October?
Maybe have oversight. Go back. Yeah, that one. What date it was.
Ms. Locklear, on your initial unofficial challenge, your challenge to the unofficial, the Board of Elections asked you in a separate letter to provide witnesses' name statements, and any facts and evidence that you have to support your allegations. Did they not?
They did.
And in your response, you provided 3 names: Mr. Barnes, Reverend Barnes. 2 other individuals you indicated did not have addresses or phone numbers, and they were Carol Locklear and Johnny Locklear.
Yes.
Did they not?
Yes.
And you provided no other witness statement, no affidavit.
As I noted, I had the flu. It was impossible. I can't remember exactly what date it was requested, but I had a set number of dates where I had to respond to the court. It was impossible for me to get out and investigate and find where these people lived, find contact information for them, because they are elders in the community.
And again, that was due on back in November 24th. Is that correct?
I don't know. I don't have that date in front of me.
And here today on December 9th, you still don't have any date. You don't have any your addresses phone.
No, I didn't know that was a requirement to follow up with that.
Nothing further.
Okay, thank you. Mr. Jody, do you, well, I provide Kendra an opportunity. Do you have any questions for Mr. Bullard? Ms. Locklear? Do you have any follow-up questions for Mr. Bullard?
Yeah, Jody was at the polls that day. How many people do you think come out of the polls that were not allowed to vote? Just in the Philadelphia community.
Hey, Ron. Cardio.
That's all.
Any other questions? Okay, thank you. Respondent, do you have any questions for Mr. Bullard?
No,
Thank you. Anything to follow up? Justice Moore?
Oh, no, ma'am.
May I ask the Elections Board a question?
We're going to have the opportunity after they respond. We're
Okay.
going to go ahead and let them, at this time, we're going to go
Alright.
ahead and let them provide their response at the podium. Well, yes, at the podium. And then when Ms. Locklear has an opportunity to ask questions of you all, you can just stay there at your seats.
Your Honor, I will be making an argument on behalf of the board, but any direct questions that the board would have in regards to exhibits or evidence, I would make the board available. And I apologize, this podium is a little bit smaller than my notebook.
Ms. Graham, if you feel comfortable, would you remove your mask if you feel comfortable?
Yes.
Thank you.
Just 1 minute. I'm going to have to remove my documents from the notebook, Your Honor. It simply does not allow the space. Your Honor, the first thing we would like to do is, if the court could turn to our memorandum of judgment, or excuse me, our memorandum in support of our petition to this, our motion to dismiss the petition. The one thing I would like to go on record for is that this is in fact an appeal, specifically Article 10 of the Constitution. Any matter decided or certified by the Tribal Elections Board shall be deemed final. Tribal action shall be reviewable by the Supreme Court of the Lumbee Constitution. We would tell the court, because we dismissed Ms. Locklear's challenge to the unofficial results, she immediately then filed her petition. This should be treated like an appeal. As such, when we set forth our issues, the issues before the court should be that in fact the Board of Elections committed any errors of law, procedure specified in ordinance or constitution, was our decision arbitrary or capricious, and whether in fact the decision was supported by competent substantial evidence. Our decision. We would give the court, by way of introduction, just the history. We have exhibits attached. We have marked them. I don't know if the court's had adequate time to review all that. I would try to refer to each one as an exhibit, but also give you the exhibit that I'm speaking of.
Yes, if you can just give us a moment to pull everything in front of us.
May I have copies of that?
Your Honor, if we can recess for 5 minutes, I can go provide a copy.
Sure. So court will be in recess for just 5 minutes, or do you need longer?
Probably less.
5 minutes, please.
Is it normal practice to give this, for me to review this 5 minutes?
Excuse me, Ms. Locklear?
Is it normal practice for me to be able to review these types of documents in 5 minutes of this length?
I'm not clear why she didn't receive documents. I don't know what to speak on that, but we can take, if you need more time to read the attachment, because a lot of the attachments are documents that have been previously provided. So if you want to read their response, do you have a copy of that or have read their response?
I have. This is the first time I've seen it.
And Your Honor, just for housekeeping purposes, that's the reason why we inquired about Mr. Bullard. Usually when the respondent responds, you get a copy and we didn't receive a copy. Usually we receive it from Mr. Roller, and in this instance we didn't, and we didn't know if it was just because of the time limit and the time restraints, but we did comply with the order.
Yeah, so Mr. Roller, can you get Mr. Bullard copies of those also? And
Yes, sir.
we're going to give Ms. Kendra, how much time do you need?
I don't think it's, if this is. I'm going to be able to review all of this within a time frame that's going to be acceptable for us to get back home to our families.
I tell you what, go over everything that we need to have in front of us. Can we do that? What you your
Certainly.
response, and then all the exhibits to make sure we have everything in place in order that we need, and then let's go from there.
Okay, so first you should have our respondent's motion to dismiss petition, and then the very first Exhibit A. Exhibit A will be the first challenge of the inefficient election results we received. Exhibit B will be our response, where we did in fact request additional information and facts, setting forth witness names, addresses, or any written statements to support the allegations. Exhibit C will be the response from the letter we received from Ms. Locklear, based upon our letter, to include attachments that were included with her response. Exhibit D will be the minutes of the November 23rd, to include minutes of October 21st meetings. Next would include minutes from the Election Board October 23rd, minutes from Election Board November 5th. Exhibit E will be the letter dismissing the challenge. F will be affidavit from Chairman Mitchell. G is the affidavit from Ms. Hammond's board member. H, affidavit from Vice Chair, Mr. Christopher Clark. I, affidavit from Ms. Gillis, who my understanding was a witness and present on the day of the election. Ms. Andrea Jacobs, who's already been identified as Andrea Branch Jacobs, Chief Judge on the day of the election. K, the special called minutes for the November 9th Board of Election meeting. L, minutes from the October 21st Board of Election meeting. M, a letter notifying tribal administrator as well as tribal enrollment, Ms. Renee Locklear, as to the date and time corrections needed for the map. N is a notice for the absentee ballots for the date and time. O being a letter in regards to tribal enrollment calendar days. And P, affidavit from Ms. Renee Locklear from the Office of Tribal Enrollment and Records in regards to the maps as well as the poll books.
Ms. Graham, can you state, can you go ahead, I think, and just go ahead and state your case, okay? we'll note that, and then after you finish stating your case, we're going to take another brief recess.
We've already put forth the issues. We've already given you a brief introductions by way of the first exhibits. So at this point, we would move away from those exhibits, simply stating forth the evidence that was produced, and we would therefore go into the allegations that we currently have under the new petition or the appeal of the challenge. The first thing we would allege in our memorandum is that based on our motion to dismiss, Ms. Locklear attempted to place burdens of proof or burdens on the board, which did not rightly belong with the board, and they had no control over it. If you will go, and I don't know if you have it, but your elections ordinance, if you have it in front of you, section 3.5, that's the first allegation that appears. Section 3 reads, the election board's authority to promulgate rules and regulations shall include, but not be limited to. And at that point, Ms. Locklear goes to section 5, distributing to candidates copy of Lumbee Constitution, ordinance on election regulations, and any other election materials. Now, if you read it word for word, there's no duty there. There's only an authority to promulgate rules and regulations. Now, that goes back to the drafting. However, we will place the duty to distribute information. There's nothing in the ordinance, there's nothing in any case law, there's nothing in your Constitution that places maintaining, changing, updating, creating the maps. This is not Ms. Locklear's first time running as a candidate, it's her second. The maps she's referring to have been in existence and in place both times. Now, if you look at the affidavit of Ms. Mitchell, which should come in under F. Ms. Mitchell sets forth the dates and times in which she was notified by Mr. Bullard about the errors in District 4 and in District 10. If you look at the dates from the time he notified the board worked with administration. The board did not have the right to change the maps or to improve them or to even call them official maps. It's not their duties. It's not within their responsibilities. However, they took it upon themselves to get with administration and fix it. When you first hear the allegations, they're changing districts. They're moving lines. That is a horrible allegation. The truth of the matter is the map just didn't have the right color in the right place. We've produced those maps. We've given you blown up covers of them because the maps that were included were photographs, so it was hard to see. So we've given you the color version. And in today's statement, she now wants to make us responsible for the map that's on the website for Lumbee Tribe. That's how you know where you should vote. And she actually asked that question. How would we know where to go if we needed to know where to vote? You go to the enrollment office. The enrollment office who issues you your ID is who tells you where to vote. That's where you go. Now, if you had questions, you could have called the Board of Elections and they would have sent you to the enrollment office. They wouldn't have got on out of their chair and looked on a map and said, look, this is your address. No. We have an affidavit from Ms. Rayner. We have an affidavit from Ms. Mitchell. It will tell you the history of these maps. They've been in place since 2014. But for Mr. Bullard, they would still be the official maps. The problem is that we're not responsible for the information. Number two, the statement that was made could have caused. That's Ms. Locklear's testimony. That is her allegation. Because the maps on the website are wrong, because the maps in their office were wrong, because the map she handed me out was wrong, it could have caused trouble. Not here's a witness who wasn't allowed to vote in their right district or was sent away because the district map was wrong. Same map she had last time she ran. Nobody's complained until Mr. Bullard pointed it out. Why? Mr. Bullard's own testimony. Know your district. He knew his district. He knew how to read a map. He came to Board of Elections and told them what was wrong. Again, we have to have some type of substantial facts that say, because your maps were wrong, your districts were wrong. No, the maps weren't wrong. The districts weren't wrong. The colors of the map were wrong. Such that Ms. Kendra Locklear says, well, I couldn't read them. If you look at the exhibit of Ms. Mitchell, it will play out the time in which it was reported by Mr. Bullard there was an error, the date and time it got fixed. It'll also reflect the date and time that Ms. Locklear says she can't remember exactly when she picked them up. Mr. Bullard testified he knew when he picked his up. Ms. Mitchell's affidavit indicates the date and time they picked up the maps. Ms. Locklear didn't pick up her map until the 1st or 2nd of November. If she had short time to get out and get the word out and get her notice out, if she was at a disadvantage, it was of her own making, because they were made notice the exact same day to both candidates. They were made notice that exact same day and made available to both candidates as to the new maps. So Ms. Locklear can show no injury to herself or no benefit or no detriment to herself than as Mr. Bullard, other than the fact that she didn't know her district. She can't produce not one witness statement that says, look, this district map was drawn wrong, and as a result, I didn't get the right to vote. She wants to put that burden on the Board of Elections because she decided these are official maps that she should only go by and she should tell people where they can and can't vote. No, you should direct people to the enrollment office if they don't know where they need to vote at. Her next statement that surprised me, that it's not her job to investigate. And that's right. The moment she made a challenge to the Board of Election and said people were not allowed to vote, wait a minute. That put the brakes on everything we did. Mr. Bullard was not certified when the rest of the districts were certified, because it is the Board of Elections' duty to investigate. And they did. She produced Mr. Reverend Barnes. You look through our affidavits, he was not eligible to vote. His membership card had expired. She gave us 2 other names, Johnny Locklear. We found one Johnny Locklear in District 4, and he was not eligible to vote. And she gave us the Carol Locklear with no address, no name. We're looking through the poll books. We're trying to contact enrollment, trying to find a Carol Locklear in District 4. Can't locate her. We investigated. What did we do next? We spoke with our judges. Judges, how many people were not allowed to vote? Were they allowed to vote provisionally? Was anybody turned away and not allowed a provisional vote? That's what the allegation says. People were turned away and not allowed a provisional vote. That's not what the board minutes say from November 9th. That's not what the witness statement says from Ms. Branch Jacobs, whose testimony appears in our exhibit. She identifies the older gentleman who got upset and left because he didn't want to vote provisionally because he was in the wrong district. She remembers. They remember Mr. Reverend Barnes. They remember the issue, and they quote that they had, in fact, with the attorney who showed up. And they had a special call meeting. They put special procedures in place so that what? Nobody would not have the right to vote. And if you showed up and you were in the wrong district and this is where you wanted to vote, you had a right to vote provisionally. What did they say? Mr. Barnes changed his mind, did not want to vote provisionally. The other gentleman who left mad did not want to vote provisionally. To this day, Ms. Locklear is not even asked to open the provisional votes we did get to see who they were or to see if these were in fact some individuals who may have qualified. She's not asked for that. At this point, all we have are allegations under 3.5 involving the map. Distribution of voter addresses. Again, this is another burden that has been, 1, adjudicated by case law, number 2, redacted by the ordinance. I put that in my memorandum. I quoted it. If you go to case law, and I can quote the case law, we have it here today. If you go to the ordinance, you will specifically see that information has not been allowed. And if you read the actual language of what she calls 3.57, it says, distribution of a list of voter addresses and any other contact information approved by the tribal membership to candidates in a format to be determined by the board. Never happened. Tribal membership has never got together and approved any type of format to be determined by the board to be distributed. Case law has. Case law says you can get limited information, and that is it. You cannot get addresses. You cannot get contact information. This court found that it would be an invasion of their privacy rights. And as a result, the tribal ordinance for disclosure of information removed the Board of Elections from that ordinance. Now, when you read maintain accurate election records in the poll books, it sounds pretty bad. But again, what do? We investigate. And we get an affidavit from the plaintiff, we get an affidavit from the people who were employed on November 9th. The poll books are not documents. They're not handwritten things or typed up things by the Board of Elections. They are generated by the Enrollment Office. The Enrollment Office holds all the power, all the cards, all the information. If your name's placed in a poll book, if your name's purged from a poll book, it comes from the Enrollment Office. Those records are delivered. Those records are maintained. They are not created. Now, are we to maintain accurate election records? Correct. 21, 3.21. Maintain accurate election records, including the poll book. During the November 9th election, you'll see in our exhibits, as well as in the text message, as well as in our special meeting, there were problems. There's always going to be problems on election day. The poll books were not inaccurate. The poll books matched enrollment records. So if the poll books match enrollment records, there's no error. That's the only duty they have, to maintain the information they were given. So when you see these affidavits and you see these allegations where these poll workers or the chief judge had to keep contacting the Board of Elections, you know what they were doing? They were fixing or correcting what was left out of the enrollment records that didn't make it to the poll books, because the enrollment records may or may not be accurate. Maybe they are. Our poll books were accurate to the enrollment records. Miss Vernetta Sutton, the attorney who wasn't allowed to vote, because of the safety precautions the board made that day having that special meeting, she was allowed to vote. Why? Because she could come in, identify herself with her information, her card showing that she was valid, and her address. If you read the special minutes, the Board of Elections put in special safety precautions that day to protect against exactly what Ms. Locklear is accusing them of not doing. So, the attorney who was her example got to vote. Where are our people who didn't get to vote? Where is anyone who was turned around and said, you're not in the poll books, you're not voting? No, read the minutes. If they are not in the poll book, you contact the Board of Elections. They will contact the Enrollment Office. Every single one that wasn't in the poll books was not in the enrollment records. What did they do next? They put in a safeguard. If you have your purple identification and you are valid, shows on the bottom your card's valid, you still get to vote. Not a provisional vote. You get to vote, even though we know that there's some kind of issue today. There's nobody here today that said, I have my card, it's valid, I should have been able to vote in District 4 and didn't get to vote. We had people didn't have ID, said they wanted to vote, said they lived in District 4. Here, you can vote provisionally. And if they open it and you should have been allowed to vote, your vote will count. But if they open it and you're not, shouldn't have been allowed to vote, it won't count. That's the definition of provisional ballot. What does the allegation say? People were turned away and not allowed to vote provisional. What does the minute say? The minute says opposite. The board had an emergency meeting and said, no, there's something going on. We're going to fix this today. Not afterwards, today. Next. Again, no witness statements, no injury. It is not her job to investigate, but it is her job to produce the evidence. It is an allegation, and here's the argument. Well, it could have caused. It could have caused. But every judge and every testimony, every statement is that we don't have not one witness. Even after the notice of this hearing, even after the challenge, which if you have Lumbee Facebook Live and Tribe on the website, people can find people. People can let you know what went wrong and how it went wrong. We're not saying that there aren't other districts who called that day and said, hey, we need this happened. We're not saying there's no mistakes. We're saying in District 4, we can find no evidence, no witness, none of the people we interviewed, none of the things we searched to corroborate her allegations, to justify giving her the relief she sought. Not even one. Under Article 2, Section 4, she quotes the Constitution. She leaves off a sentence. subject to the ordinance. And it's a good argument. If you're a general member and you're eligible, you should be allowed to vote. Key word, eligible. If you walk in the door and you say, I'm a Lumbee tribal member, I'm here to vote, I don't have any proof that I'm eligible, guess what you still get to do? You still get to cast a provisional ballot. She's alleging people were turned away walking in the door saying, I'm a Lumbee tribal member and I should be entitled to vote. Where are they? We had one person from that district vote provisionally, and the other ones who were offered left and decided not to. The other ones in our sworn testimony said, I'll go to my right district. You heard Mr. Buller testify. People come in there that said, well, I vote here for everything. I've always voted here. Where you vote for the president and the state of North Carolina is not where you vote for tribal elections. Now, based on Facebook and the statements we've had, Ms. Locklear's testimony is, I didn't have time to gather witnesses. I was sick, and in the middle of COVID, we can justify that. We are now at December 9th. From a November 9th election. You've now had 30 days. And I still don't have a witness in the audience. I still don't have a witness statement. I don't have anybody to support your allegations but you. As the Board of Elections, we have to have more to that to attack the integrity of our election. Because it's not that you say that something went wrong or that we did something wrong procedurally. It's that there is something that has happened that we can provide proof for based on the reading of the ordinance. And the ordinance is pretty clear. Substantial and material irregularities that would have changed the outcome of the election. Or at least made it mathematically uncertain. I don't have one witness. I don't have one witness statement. Everyone we've interviewed cannot justify that any of the allegations are supported by any facts. Did we see people leave mad? Yes. We have witness statements and affidavits where people were told you're in the wrong district. We can let you go there and vote, or we can let you vote here provisionally. No doubt in my mind there's some people who left and didn't go nowhere. But you had a choice. You had a right to vote provisionally, or you had a right to go to your right district. If you make that decision and leave mad, there's nothing in the law or procedures to protect you from that. That's a decision that you made. In 42A, she did the same thing. If you read in the election under 42A, which I can only assume to mean voting section 4, voting procedure A, she leaves off the rest of the sentence. Any eligible voter may be able to vote by appearing and simply announcing your name. Under that voting procedure, if you look at your ordinance, there is a B, a C, a D, a E, a F, a G, and a H. That's the thing about the reading of the law. You don't get to pick and choose what you want to apply in one sentence. You've got to read the remaining paragraphs for you to completely understand what that section means. And yes, under section A, you can show up anywhere you want to, announce who you are, and cast a provisional vote. But if you want to cast a vote, you got to follow B, C, D, E, F, and G, and H. We have procedures in place. We just don't get to walk in and say, I'm Lumbee, I'm going to vote today, and I'm going to vote a regular ballot like everybody else. And that's what her argument is under 4.2A. And we simply disagree. And maybe, like she said, she's seeing people leave out. All she knows is they walked in. Her testimony never is that she was in earshot or that she heard someone being told you cannot cast a provisional vote. Only that she would see people leaving mad that she couldn't identify, didn't have a conversation with based on her testimony, but just seen them leave mad and heard them say, I'm voted here all my life and now I can't vote. You're hearing one part of the story. The remaining part of the story are in our attached affidavits, where the Board of Elections worked all day long to make sure eligible people got to vote and cast a ballot. People who may or may not be eligible, even Mr. Reverend Barnes, who we found out his card was later expired, could have still cast a provisional ballot and decided not to. You can't just hear part of the story, because if you walk in here today and you hear our elders were turned away and not allowed to vote, you certainly become enraged. Because as the Board of Election, when we received her challenge, wait a minute, put the brakes on. We need to investigate, and she needs to provide facts. Well, Judge, I'm here to tell you today, the Board of Elections did their job. They went out and they investigated. And we couldn't find any facts to support it. We asked her to provide facts to support it. And here we are 30 days later with mere allegation. Could have caused. Her next argument is absentee ballots. And this is one under 5.1E. I had to read it, then I had to read it again under Section 6 because I couldn't understand how she was applying the law. She placed it as 5.1E. Absentee ballot shall consist of a ballot which otherwise meets the requirements of this ordinance, an outer envelope, instructions sheet, ballot secrecy envelope, and a return envelope. The only thing I could get out of that was the return envelope because I couldn't see how any of the other ones had anything to do with her fact she alleged. So these are the absentee ballots. Her first problem is she got the number of absentee ballots wrong. And if you look at Exhibit, just one moment. Exhibit G, Lakeisha Hammonds' statement, and Ms. Lakeisha's here today for additional questioning. In Ms. Locklear's challenge, she alleges there were 6 absentee ballots that didn't come back. That's impossible if you read Ms. Lakeisha Hammonds' statement because she tells you exactly how many were sent out, exactly how many were received back, and exactly how many were not received. Now, she's the Board of Elections. She knows. She should be the person who knows. We do not have 6 unreceived board absentee ballots. At this point, the count is what? Count was 6, and now we're down to 3. 6 absentee ballots in total, and now we're down to 3. And again, all those numbers appear in Ms. Lakeisha Oxendine's Exhibit G. So let's just make the argument say.
Just one question there. Is that 6 ballots
that were
from District 4? Or is that 6 ballots total?
We're only talking about District 4 here today.
So everything, all statements is just District 4.
So the most important information you're going to see is going to be on the second page of her Exhibit G, if you want me to go over with it, just so we can do the math. So 8 people who applied for an absentee ballot were accepted. 4 of those were returned by 11/12. So that leaves 4 possibly outstanding after 11/12. One of those 4 was rejected because the signature was wrong. 3 was accepted. And during the count, 1 was void, and the other 2 voted for Kendra. 1 returned after the deadline of 11/12. 4.
So just to be clear, 4 of the ones that were returned by 11/12.
1 was rejected.
1 was rejected. 2 voted for Kendra.
3 were accepted. So 1 was ejected. 3 remaining were accepted. 1 was void, and 2 voted for Kendra.
Gotcha.
All right. Now, that's your 4. The 5th one returned after the deadline. It's returned. It made it back. Not a postage issue. It just came in after November 12th. That only leaves the mathematic possibility of 3. So let's just give her the benefit of the doubt and say she's 100% right. That there were 3 absentee ballots that should have came back, didn't come back because of postage. Still wouldn't change the outcome of the election if you believe it. It's 102 to 106. 3 wouldn't do it. Now, let's do what case law has done.
Ms. Graham, I'm going to ask, we're talking hypothetically here a little bit. If those 3 were in her favor,
it would not have changed the outcome of the election.
What is your understanding? What would the numbers be then, hypothetically, if they were in her favor?
She had 102. Her number would be 105. His would be 106.
Okay, so hypothetically speaking, what is your understanding of the margin as written that is required for a new election or a
Hypothetically, if we had had 3 return or had received 3 that said your postage is wrong, then you could make the argument that she's making. Those could have been my 3 votes. I should be entitled to a new election or runoff election, which is what you're speaking of. However, guess what? With the Board of Elections, we can investigate. We know who those 3 belong to. We can pick up the phone, talk to them. How was the process? What happened? Did you have any problem? One of them died a month ago. The other 2, no problems, never received it, didn't have anything to do with postage. We still haven't received it. If there had been a problem with postage, based on the affidavit that we have in here from the postmaster, 1 or 2 things would have happened. It would have had to return to the person who received it or sent it, or the person who was responsible for receiving it. There have been no allegations based on those 3. And this is after, again, our investigation. We asked Ms. Locklear, provide your facts. Who didn't get their postage? Who needed their postage paid for? Whose postage was in error? I don't know. I just found this picture somebody had took a picture of and said it was one that was out there. Read our affidavit. We found 2. We paid for them. We got them in. We have the right to investigate. We have the obligation to investigate. We've investigated Ms. Locklear's claim. Let's do it the other way. Let's say, okay, if the absentee process, based on her allegations that somehow the court didn't consider that November the 11th was a holiday and the mail wouldn't get there by the 12th, let's wipe out all the absentee ballots because the court order somehow didn't consider November 11th being a holiday. Even if you wipe out all the absentee ballots, it wouldn't change the outcome of the election. Mr. Bullard would still have 1 seats. She would have 2 less. We've done it both ways, Your Honor. That was our duty to investigate. If we had found that there was this material possibility, we wouldn't be here today. We would be doing exactly what you said, hypothetically. What if it was true? But we didn't. We investigated. That's our job. We asked for additional evidence in case we missed some. Maybe there's something you have we don't have. There's nothing there. And we know there's nothing there because we investigate. As to 65A, the outcome of the election would have been different. Ms. Locklear has failed to show any procedure or any evidence to show any procedure that we used that day that violated any law, that any of our procedures caused her a disadvantage or an advantage to Mr. Bullard. And there's case law on that. You have to show not only that there was, according to the ordinance, irregularities. You've got to show, 1, there are material irregularities, and that as a result of those irregularities, the outcome would have been contrary to report. The case law, apologize, Your Honor, I've got to pull it out. The case law is Samuel Kearns versus Harold Oxendine, an election case. Nobody's here today to say,
Do you have that?
oh, I'm sorry, Your Honor, I can give you the case number, and I can hand it up.
Case number and you have date or Matt, Mr. Roller, do you have a copy of that, or could we get a copy of that? The one that she's referring to?
Ms. Graham, was it in your memorandum?
No, it's just in my argument.
No, Your Honor, we don't have a copy of it.
It's on your website. It's 2008-01, case number 2008-03. Samuel Kearns petitioner versus Lumbee Tribe Board of Elections. Harold Oxendine petitioner versus Lumbee Tribe Board of Elections.
Give us one moment just to pull that up. Sorry. Okay.
Okay. Now, in this case, there were irregularities. Strange things happen. Court found under 6.58 that although there may be irregularities, they have to be material and substantial in nature. Ms. Locklear is alleging that a map that had existed from 2014 and set through her last election, as well as this current election, somehow injured her, didn't place her opponent at a disadvantage, and didn't place him at an advantage, but somehow could have caused the outcome of the election to be different. We would tell the court that that is of not material or substantial in nature. Even without that map, if you don't know where to vote, they would send you and tell you what district you needed to be in to vote. If you didn't know where to vote, you should have contacted the enrollment office and found out. Did they put procedures in place that day to make sure people were protected? Yes. Is there any witness present here today, 30 days later, any witness statement, any affidavit that says, I should have been allowed to vote in District 4 and was not allowed? No. You can't blame that on a map. Our next allegation is about postage.
Let's just a second. Let's back up to the maps for a comment or two. Do you agree, or does the Board of Election agree, that I have one in front of me that dated 2014? I think that's the one you cited or spoke of, right?
That is the one that has hung in the Board of Elections office since 2014.
And then I have another one that says correction for Tribal Enrollment Manager, October of 2021.
Yes, that is the corrected map.
Okay, and the only difference
is color.
Well, it's not just color. There's an additional road or part of a dead-end road. I know exactly where the road is. That's added in 2021. Are you familiar with that?
Your Honor, the only thing we are aware of, based on the maps, is that the color was changed. The district line was not changed. There was not an added area. You cannot say that the district map included a new line. It was only included in color. It already existed in the district. You were already in the district. The map just didn't show you in the district because of color.
So you're just saying the color that I'm looking at is a little bit different, not much. That's just all it is color.
That is exactly what.
Does it have anything to do with people changing or voters changing district or being in a district?
If you look at the affidavit from Ms. Reyna, who's responsible for making the change to the map, if you look at the affidavit for the people who were involved in the map changing, it is color. It states it in the minutes that it's color. It states it in the letter that it's color, and it states it in the affidavit of Ms. Reyna. Nobody created a new district. Nobody added a new address or a new territory. It was already there in the district. You could vote District 4. Your color on the map did not reflect that.
But as a candidate, if I'm getting out and meet and greeting and trying to get votes, wouldn't that be a little confusing?
It may be confusion, Your Honor, but again, if you have a question about where you vote, it does not lie with the Board of Elections. We do not create addresses, districts. We do not tell you where you vote.
Well,
it goes to the enrollment office.
Of the candidate. I'm speaking for Ms. Kendra. If she looks at this map and she says, well, this street's not in my district, right? So she just assumes that those people can't vote for her. But when those same people go to the polls, they actually can vote for her.
That's great.
So that is a little confusing for her if she can't, whatever, how she conducts her candidacy, knocking on doors or whatever. That is a little confusing that she can't travel down Dixie Drive. And I don't even know how many people live down Dixie Drive. That's a little confusing that she can't go down there and try to earn those votes.
And again, Your Honor, that ordinance that she's quoting that we violated law does not place that duty upon us. The duty is only that of handing out and distributing, not maintaining, not updating, not making changes. If you read the letter and the minutes, it indicates the Board of Elections couldn't even change the map when it knew it was wrong. It didn't have authority. It can only come from administration. We were not responsible for the information that was distributed, and that's the burden she attempts to place that the ordinance does not. Now, if you allege that's an irregularity, show me how you're at a disadvantage from that, versus him being at an advantage from the Board of Elections. Because again, this is an appeal. This is a review of what we're doing. There's been no showing. There's been no facts to support could have caused. The Board of Election is not willing to set aside an election, order a new election on could have caused, unless that irregularity is supported by evidence and facts. We don't know that Ms. Locklear, when she got the new map, went out to Jones. We know we gave it a tour in enough time where she could have. And in that case as well, where it talks about material or substantial nature, it talks about the safeguards the Board of Elections put in place and the procedures. They did not deprive the petitioner any votes. The procedure of the outcome would have changed in any way, and it did not place the petitioner at a disadvantage and did not give any advantage to the opposing party. Nothing that was done procedurally has been shown to place Ms. Locklear at a disadvantage, giving Mr. Bullard an advantage over her. The map was available. She waited 7 more days to come pick it up. And according to you, it's a dirt road. How many people could live on that dirt road that she didn't have 7, 8 days to go and campaign for? Because she knew on October 21st. That's when she's notified. There again, she wants to place burdens on the Board of Elections. What did the Board of Elections do? They investigated. That's what we do. That's our job. We could find no evidence. We could find no witness. We asked her for one. Tell me somebody who wasn't allowed to vote because of that map, that got turned away from District 4 because they said their address wasn't where it's supposed to be. Nobody. You got to show that somebody didn't get a right to vote because of the map. She wants to say she was injured because she didn't have a right to go out and meet and greet people. She had, from the day the map was available, to go out to the drive and meet everybody on the sidewalk. And we don't know how many more days she would have had if she'd have picked it up on October 28th, when it was ready and available to her. There is no disadvantage to her. It wasn't a disadvantage to Mr. Bullard. Got it the exact same day.
Question: can you explain why there are discrepancies among the maps? Like why it looks different than the one on the website?
I don't even know that we ever looked at the one on the website because that was not a part of our information we were distributing. I can only tell you that there was a lawsuit sometime in 2016, 14 maybe, in regards to the maps, and the maps were redrawn for other districts. It was not 4 and it was not 10, but there were other districts where the maps were created with a lawsuit. And that's probably when they went back, redone, and that's probably where you get the 16 from that she's looking at that's on the website. District maps that we have were not a part of that lawsuit, and so no, we don't have access to what's on the website.
Who's responsible for updating the map on the website? Do y'all know?
I would say administration, because council creates the districts, but it would be administration as far as providing information. And it's only administration who could change them. And if you look at the affidavit from Ms. Rena and the notes and the minutes and the letter that had to go to administration to even get approval for us to change it. And we didn't change it. We had to get approval for them to request that it be changed.
Have y'all had a conversation with them about the map on the website being updated?
They know about it. I mean, because administration had to be part of the change. Now, whether they've done it or not.
I see that as very concerning because the public rely on the website for information, especially folks that may not have access to social media or, transportation to get to see a physical map in the Board of Elections. So that's just concerning that may need to be discussed at some point.
Yeah, so if I'm a tribe member and I walk in the front doors and I ask for an official district map, it doesn't matter which district, I just want an official map. Where does it come from?
It's going to have to come from administration. They would be responsible for paying for it to be done.
Administration, like the enrollment office or certain department in the administration, or who would you say?
It has to be an enrollment office, because if you see the letter that went out where they had to get permission
tribal administrator.
And is that in the affidavit that Ms. Rena
Yes.
supplied?
It's right. Ms. Rena's affidavit's Exhibit P, and there's also a letter that went out. And that letter is M, because the Board of Elections doesn't have authority to change it, even to fix it when you see there's an error. Because we don't, again, maintaining and distributing something is not the same as being responsible for the information.
What's your communication like with them during the biggest rush during election season? How often are you in correspondence with the enrollment office, and how thorough would you say that is? Just maybe explain that process to us.
I've heard of Rena probably a couple times. Well, I talked to Rena a lot during election day. And then leading up to election day, probably maybe a couple times a day. Just really.
And what do those conversations consist of?
Well, with the absentees, it's basically if I can't find them, I have to go through her to check to see if they're active or inactive. And that's basically our conversations are just about absence.
Seeing Rena's letter right here. Yes.
Have been conversations, about the map, especially, and I think it was 20, maybe 13, 14, maybe 14, a case law with Larry Townsend, who challenged the former Ms. Carveckers Barfield. And I think in that case was mention of the maps on the tribe's website where you could not read them clearly as far as the roads and that. And I think, and it is my view, and in my statement, the view of this current board, that maybe in 2014, because I think that case was before 2014, that maybe they just enlarged the maps at the board so that you could read the streets. The only thing they did was zoom in, make it bigger so it was readable. But you can't find that on the tribe's website, even if you pull it up, because I've tried it. I've tried to pull it up to read those, and it's real blur. So there was, that challenge back, I think it was 2014 case law with Larry Townsend versus Carveckers Barfield, and actually it was the full council. So, but the maps that we have at the office is the original maps based on Miss Rena's testimony and her affidavit, based on her, in my statement, her coming to the election board's office. Those are official maps. They're just large where you can see the roads and everything. And then, the maps were there before this board came there with that color incorrection.
What happened, Madam Justice, is we had decided this year that we were going to do something extra for our candidates and give them a larger map. And when Jody phoned us and he said, hey, there's an error on these maps, there's a road missing. And we assumed that Lumbee River Council of Governments had made an error when they made the maps larger. So we contacted Lumbee River Council of Governments and we said, hey, you guys have made an error. You need to correct that error so we can give the candidates the correct maps. And they immediately said, we didn't make an error. This is what we have here on our CD, and we can't correct it. And you have to get a letter from the tribe in order for us to make any changes on this map. And so that's why we contacted the tribe and said, hey, they have the wrong information, and we have to get the correct information to these candidates ASAP because the maps that they have is incorrect. And so that's why we had to contact the tribe and say, please give them a letter to get the correct information so we can get the correct information to these candidates ASAP.
When you
because
say
they're
the
canvassing.
tribe, who at the tribe?
Miss Rena,
Okay.
the affidavit that you have had to give them the authority to give us the correct maps to get to these candidates so that they could get to canvassing their, constituents.
And did they complied and then got the map
Yes, ma'am.
corrected, and then you all had the corrected map and gave it to the candidates.
That's
Did you
correct.
give a corrected map to the enrollment office?
They have the corrected ones.
Okay.
We just, on our walls, did not, and we did not know it until Mr. Buller contacted us. And as soon as he contacted us, we made sure to contact the other candidate as well to make her aware that, hey, there's a problem with the maps. We're trying to get them corrected for you.
Mr. Jody, who or how were you made aware that there was a flaw in the maps?
You know, these two members of the board contact current resident asked not before always.
Okay, thank you, sir. Ms. Graham, you can continue if you have anything further. If you have any more questions.
Your Honor, the last argument we have is that it would be impossible to determine with mathematical certainty which candidate is entitled to be certified as elected. And that would be true if we had any affidavits, if we had any statements that could support Ms. Locklear's allegations. And this is the thing about the Board of Elections. If she had walked in with 5 affidavits, maybe even, like you said, 3, to get it to the point where it was within the 1% margin, and she would have been entitled. But we didn't have anything. We investigated every allegation that she made. The information provided with the maps provided the exact same day. She didn't pick it up until later. October 28th, with the number of people that she would have had invested, she could have sent all of the letters at that point in time. And again, there is no allegations supporting facts of why she didn't get to do it, or who missed out, or who didn't get to vote for because she didn't do it. It's just one of those things that could have caused. And I'm here to tell the court there is irregularity. It's not substantial. It's not material. It's the same map she ran with. She ran in the last term. It's the same map the other candidate had. When the information was made available, she was not at a disadvantage. She made it available to her the exact same day. When the information came in that there was an error, she got that information the exact same day. You cannot claim a disadvantage unless you can show facts to show how somehow you were placed at a disadvantage and Mr. Buller was placed at an advantage. It's the exact same error. Mathematically, with the absentee ballots, we've gone both ways. Take them all out, wouldn't apply. Wouldn't change anything. We've investigated absentee ballots. Based on the allegations she made, repeated the phone, called the 3 individuals. Would not change the outcome. We do not believe, based on the dismissal of her petition the first time around, and now again asking for it 30 days later, that there's any substantial evidence to support her allegations. They are horrible allegations. And if anyone was not allowed to vote provisionally, they should have been here on their own today. They should have been contacting the Board of Elections themselves. If anybody was not allowed to vote that should have been to vote or been sent to the wrong district and couldn't vote, they should have been contacting the Board of Elections. She gave us 3 names. We investigated all 3 names. She accused us with the absentee ballot. We investigated every single one that wasn't returned. At this point, Judge, we're simply saying we do not have any facts to support the allegation. All we have is could have caused. And yes, there were irregularities. There were procedures put in place to safeguard that people could vote, even vote provisionally. And you can allege that people were turned away and not allowed to vote. That's not what our affidavits say. That's not what the evidence we have submitted said. And I'm sorry, Ms. Locklear has submitted 0.
And these procedures that were put in place, they were put in place for the entire election, correct?
That's correct. And had we received that evidence, Your Honor, I will tell this court, Board of Elections wants to be transparent. We even had an officer of the court monitoring what they did that day. If Ms. Locklear had brought us the evidence, brought us the witnesses, and said they had been denied the right to vote,
Judge, we might have had different outcome. We might not be here today. Even today, and on the 9th, I still expected something. I expected some witness to be here to testify how they were mistreated or how they were denied their rights. And again, we just asked the court to support our ruling and uphold the integrity of the elections, because we simply cannot award a new election based on allegations of what could have happened.
Are you aware, or anyone on the board, or do you have any knowledge of, at any time, where a new election has been ordered by the Supreme Court or by the election board?
Yes, there were times when people who should not have been allowed to vote, which means should not have been allowed to come in and vote in the Board of Elections, and they were allowed. They were issued a new election at the Board of Elections. That's one case. The second case is where they were not getting identification, and there were people who come in and were allowed to vote because the board wasn't doing its job with identification.
Was that on the same day as the original election date? Is that what you mean?
With those cases?
Yes.
So essentially, people came out of district or were in the wrong district, voting in the wrong place. So you affected the outcome of that election because you shouldn't have been allowed to vote there. That's the case that was set aside with the Board of Elections in their challenging. The next case is where the Board of Election wasn't getting ID properly and allowing people to come in and vote, and the Supreme Court sent it back.
And when you say send it back,
They
did
ordered
they
a new
actually
election.
schedule a new election just for that district? Said district?
I'm not going to say it was a district or how wide it was, but I'm assuming it was a district. But it's a case I've read, so yes.
Is anybody familiar with what Ms. Graham's talking about? Which case?
I think it was Burnett, and I'd have to look it up on courts.
Yeah, I simply read through the court's decisions and took notes as to when had this happened before and under what circumstance. In each circumstances, they actually had written affidavits from people who witnessed what had happened and who had actually been allowed to vote themselves and came in and gave a witness statement or even testified. And in the case with the Board of Elections, they had witness statements where people said, we shouldn't have been allowed to vote in that district, and we were allowed to vote. And the margins were so close that they had to order a new election because you should not have been allowed to vote in that council race. But it came down to voters. It didn't come down to, and that was simply a counting case because they had enough witnesses. And again, we would argue to the court, if we had witness statements and witness affidavits and witnesses, we may not be standing here today.
If we could find those cases, that would be very helpful.
Mr. Matt, are you familiar with either one?
No, sir, but I can certainly look while y'all continue.
If you can. Ms. Graham, you don't know.
I've read through them, Your Honor, because I wanted to see what the facts were when they ordered a new election, and every single case that I read came down to people who either weren't supposed to vote in that district, right, or people voting who weren't supposed to vote and did vote, or people who, that's right, same thing. One was they voted and shouldn't have voted. The other one was they were voting without identification. So you couldn't even prove if they should have been there or they shouldn't have been there.
Case Anita and Elaine, that case was heard by the Board of Elections.
And they ordered a new.
But that was the same thing. Is that they voted there wrong. But that the other case on the website.
Your Honors, if I may, it's Ricky Burnett v. Lumbee Tribe Election Boards 2004-009, and a new the court did order the petitioner is entitled to a new election.
And I would just note for the court, in both cases, there were witness statements, witness testimony about the irregularities that had actually occurred.
Anything else, Ms. Graham?
No, Your Honor. We just make the board available. If you have any questions specifically about their facts or their evidence.
Anything else from any of the board members? Any comments? Mary Beth, do you have any more questions?
No, not at this time.
Okay, at this time, we're going to take another brief rest.
Excuse me.
We're going to take about it's 5:33. Let's be back in here at 5:45. Court's in recess.
All rise.
Thank you. You may be seated.
Your Honor, may I correct a misstatement that was made earlier?
Court's back in session. Yes, ma'am.
Earlier, and do you want me to go to the podium or correct what I stated?
You take, if you can just remove your mask, you can be fine right there, Miss Graham.
In earlier's question, there was a question about a word, and the court used the word runoff. And I'm sorry, the ordinance allows an automatic recount at we don't have election runoff.
Okay.
So even if she had been given the 3 absentee votes, the only thing it would have allowed was an automatic recount, not a runoff. So we don't have runoff election. What would have happened is the vote would have been 105, 106, but it would have been entitled to an automatic recount. Now, other than that, we don't have any of these other than a flip the coin for a tie. So we only have automatic recount, flip the coin for a tie. We don't have runoffs or in the order. But the court used the word runoff, and I simply followed along because of the consent, but it's not runoff. It's
So if it falls, within that 1%, then it's basically a recount, and then if the number's the same, it's a coin flip.
Well, if the numbers are tied,
Or tied,
it's a coin flip. At that case, it would have been 105, 106, so all it would have got was a recount. It would not have gotten a runoff. And I'm sorry, I heard the word, I recognized the consent, and I agreed with the language, but the language don't have it would stay 105, 106, just count change.
So even if the number would have, even after a recount, without the number being tied, but votes being tied, Mr. Biller would have still been certified.
That's correct, Your Honor, and that was our argument, that either way, gave her every single vote, even based on her allegation, would have been 105, 106. If you took away every single absentee vote out of the pot, it still would have been her losing the vote for staying there. So, making the argument, no matter which way you went on the absentee ballot, it would not affect the outcome of the election.
Okay. Anything else?
I just wanted the court to know that the runoff was wrong.
Gotcha. Thank you, ma'am. Thank you. We apologize. I said 5:45, and it's about 6:41, so we apologize for taking a little more time than stated. However, me and Justice Mary Beth Locklear, we spent the time very efficiently, and first thing we want to do is be fair. We want to be fair to this current case, and we want to uphold the integrity and the fairness to not only the parties involved, but the entire tribe. So with that being said, Miss Kendra, what we've decided on right now is a couple of options. You stated that tonight or this evening, I think it was 48-page response that came from the Board of Elections. That's the first time you had saw it, right? And I don't know if that's been, I don't want to say it's not been fair, but I don't think it's the right way to go about doing certain things if it's the first time you've seen it. So we're gonna offer two options. We want to be fair in your opportunities to review it. So we got to set some time frame of how long that might be. Is the first order, right? If that's the option you take, right, you'll be able to review it. We'll agree on the time to come back, and you will be able to ask your questions to Ms. Graham or to the respondent. There will be absolutely no new evidence, no new witnesses, no new documents that can be submitted. With that being said, that's option one.
Yes, and if you if we return on that date and you do have questions, the questions will be based solely on the testimony that you heard this evening and the documents that were presented during the testimony in that packet.
And of course, the time is, if you look at the calendar right now, I think January 6th is actually the
Yes, sir. January 6th is going to be the inauguration and swearing in ceremony.
So time is, if you agree, or if this is what you take, time is definitely of the essence for option one that I just discussed. All right. Second option would be basically to take all the evidence and testimony that you heard tonight, including 48-page response from the board, and basically we'll proceed right now. If you think you're prepared enough to ask questions and get the answers that you seek, we'll do it right now.
I'm ready. I'm ready to get it over with.
If you need to take a few minutes
No,
to
I'm
even
ready.
think about it,
I'm ready to go.
right,
I'm ready
just
to
a
get
second.
it over.
So now, excuse. Okay, so we'll proceed then with Ms. Locklear having the opportunity to ask questions. First to Mr. Bullard, if you have anything that you would like to say based on what he's mentioned tonight, followed by any questions you have for the respondent.
Yeah. The only reason I'm saying tonight is because I'm going on a cruise. I don't want to delay everybody's time in this room. So that's the only reason I'm saying yes. I have not had enough time to review all of this information.
And Ms. Kendra,
and I want to be
understand.
respectful of everybody's time.
Is my mic on? Understand that we are willing to offer some time. Okay? I don't want you to feel like I want you to be afforded fair opportunity.
Okay, if you're going to offer time, I just wanted to put that out there. I'm going on a cruise. So I won't have any access to internet, phone, nothing.
Okay. What are cruise dates? What are your cruise dates?
The 18th through the 20th. I mean what's the date? I leave the 11th. It's the 11th to the 18th. And I actually leave tomorrow night. I fly out tonight.
To return when?
The 18th. My flight's back in, that's on a Sunday. My flight back in Raleigh on 2 a.m. My kids on Monday morning.
Okay, well, the ball's still in your court. If you want to do it, if you want to accept option one, we will schedule around that.
Okay.
It would probably, we would discuss that. Or if you want to go with option two, we're ready to do that also.
I'll go with option one.
If we're looking at dates, I just want to make the court aware the only dates I'll be available will be the 28th and 29th. Because we will actually shut down on the 17th.
I'm pulling up the calendar really quick.
Again, that only leaves the 29th.
tribe is closed when?
That week, the tribe will be closed Monday and Tuesday, Friday. Recognized holiday.
29th will be on that Wednesday.
The tribe will be open. Correct. Friday's the 30th, correct?
Thursday.
Thursday's the 30th. So then, yeah, the tribe will be closed Friday, Monday, and Tuesday.
Miss Graham, what dates were you available?
If the tribe will be closed the 28th, Your Honor, it'll only leave me the 29th. Close on the 17th. And don't come back in until the 28th and the 29th. We go back out on the 30th. I think. Oh,
Miss Kendra, what dates would you be available? In person? No problem.
what date?
Right now it's just the 29th, I think, right? It's 29th.
Right.
So with the 29th, Miss Kendra being available, I guess we're in agreement that you want to do the first option. Is that correct? You understand that no new material, no new evidence, no new witnesses or anything will be permitted or allowed, correct? So I think with that being said, I think we can agree on the 29th. I don't know exactly what time we can agree on now. I think that's the only thing we can agree on right now. Any comments, Ms. Kendra? Any more comments? Mr. Bullard? Okay.
Maybe. Also, I got out. Hello. I don't. Goodbye. Four. Oh, but I'm voting. I got out. Wait. Got out. Sweet. Oh. And no pump. Yeah. Sweaty doesn't vote. For most vote. Ask for this. Got out.
Thank you, Mr. Bullard. Any response or comments from Board of Elections? Anybody?
Okay.
All right, with that being said, we're going to set the date for the 29th, December 29, 2021. We will contact, or our line of communication will be Mr. Matt. He should have everyone's email, right?
Yes, sir.
We'll set a time for the 29th, and at that time we'll resume exactly where we're leaving from now. Ms. Kendra, it will be on you when we start back for your questions that you have, if any for Mr. Bullard, but definitely for the Board of Elections. Okay? With that being said, this court is in recess until 29th at the determined time. Thank you.
All rise.